I have instructions. I've put forth my level of understanding in the procedure. That is the 2014 and 2015 procedure late, and the chairperson indicated that the procedure can be changed any time. But however, I need to note that the procedure that we have is the current one that is on the CRL website. There's no amended one. Further, my instructions are that on my objection that I've noted, it's important that the Commission should give us a decision as to how they're going to proceed. For me to take further instructions as to whether should we approach the court to apply for review of such decisions made. Thirdly, my instructions are further. The summons, section 7.2 summons is before us. It must be noted that initially it was said the complaint in South African Council of Churches on the face value of it. Now what the Commission is saying today is totally different. Say we're doing an investigative study. So now the question which one has to ask themselves is, are we now here on the same summons which we are called to come and testify on it, or are we now on the investigative study? Those are two different things. My instruction that I had on the initial, on the previous occasion when I left here, was solely on the document that were presented to us. The first document being the one which was provided on the same day by respectful Commissioner Gota, and also the summons that I have, which the face of it indicates the place where the Commission is going to sit, the room, the date of the hearing, and the complainant. Now, if the Commission is coming today and saying that this is an investigative study, I don't have instruction on that. In that light, as soon as the Commission has made a decision, I'll make my application to that.
It's fine. You have your rights. We have our rights. We've issued summons, and we've asked your client to present himself as per the summons. He's got his rights, and we've got our rights. If he is refusing to cooperate with the summons issued as per Section 7 of the CRL Rights Commission, Section 41 of the CRL Rights Commission will then have to kick in. I'll hand over to Commissioner Botha to explain this to his learned friend.
I would like to understand at this time, are you refusing to comply with the summons as issued, to appear before this commission, to answer to questions as posed within the summons, and to produce documentation as found within the summons? Yes or no?
It must be very clear before this Commission. At no stage have we addressed the Commission that we are refusing to finish the Commission with any document. It was never indicated before the Commission. When I came in now after 5 minutes agenda, I asked the Commission to make a decision on my application which was made before, on the procedural aspect that I raised.
Okay. On your decision, on the decision that you're requesting, we have already stated our position as the Commission.
Commissioner Botha, maybe let me just check, because there were two summons. One with the complainant being SACC, and which summon was withdrawn, followed by a summon without a complainant. I just want to check if they received the second summon.
The summons that we received is this summons, which I was saying on record that it includes the place, the room number, the date and time of the hearing, and the complaint. This is the summons which entails. This is the summons that entails the complaint. Now, the chairperson today is saying this is an investigative study. I'm saying when we took instruction, when we postponed this matter on the previous occasion, we took instruction on the summons that is before us. We haven't received any summons whereby the complainant withdrew her or his summons, or that particular institution withdrew their summons. We're still sitting with the same. I still need to make it very, very clear that my instructions are that the ministry does not object or has not made any utterances that they refuse to finish the commission with any documents. They haven't. We've respected this commission. Summons were given to Pastor Lesego in a small space of time, but he availed himself. On the 3rd of November, this commission postponed this matter to the 16th of November. We never disrespected the postponement. The matter was postponed to be heard by 11 o'clock. We're here by 11 o'clock. We respected the postponement by the commission. What we're saying now to the commission is, on the document that were presented to us on the previous occasion, we took instruction accordingly, and we've put our argument. We requested the commission to give a decision on the objection that has been noted initially. If the decision does not suit Pastor Lesego, then there's legal recourse to do that. But the commission, when the commission say they rely on the respective section, that of imprisonment, we are here. We're not running away. He's not running away. He has been here previously. He's here today. But we want this matter to be adjudicated in a proper manner. We're not going to exempt proceedings whereby we see that they are not meant to be exempt. We need to do the appropriate. Thank you.
Can we explain to you again that this whole process is Section 7 of the CRL Rights Act and not the functions of a Section 22 committee? The CRL Rights Act is very clear. Section 5(1)(e). Let me read it so that we're on record. The Commission may do all that is necessary or expedient to achieve its objects referred to in Section 4, which is to promote and protect the religion in this matter, including to monitor, investigate, and research any issue, whether there's a complainant or not, concerning the rights of cultural, religious, and linguistic communities. And then Section 7 says, the Commission may conduct an investigation in terms of Section 5(1)(e), that I've just read to you, itself, or may designate one or more Commission members or other persons as an investigating committee to conduct the investigation on its behalf. This is the committee that the Commission has put in place. For purposes of an investigation, the Commission or investigating committee may, by notice in writing, summon a person to appear before the Commission or the committee, as the case may be, to give evidence or to produce a document available to that person and specified in the summons, or call any person present at a meeting, whether summoned or not, to give evidence before the Commission or committee as the case may be, to produce a document in that person's custody at the meeting. C, administer an oath or solemn affirmation to a person contemplated in paragraph B above. D, question any person contemplated in paragraph C, or have such a person questioned by a person designated by the commission or committee, as the case may be. So, there's this investigative committee that has been set up as per section 7 of that committee. Let me read further powers and functions of the committee. We can do all that is necessary to, for instance, assist in the development of strategies that facilitate the full and active participation of cultural, religious, and linguistic communities in nation building. And we feel we're in that process now of nation building. And we can promote awareness among the youth of South Africa of the diversity of CRL communities. And the most important thing is that we can develop any strategy. And then 5.1 takes us to 7. And 7 takes us to section 41. Section 41, of course, is that if you fail to cooperate, or you refuse to cooperate, or you put up excuses for lack of cooperation, or we are advised not to cooperate, we have to do what we have to do. We're talking about a summons. The summons is here in front of us. We can come up with a whole range of other stories here and say this and this and that. We've got summons. And the Act allows us to ask questions in order for us to develop those strategies that will help the nation. We're looking at nation building. We're looking at normalizing the country. We're looking at a whole range of things. Why in an investigative study? And nothing stops us when you come here to say, by the way, someone did complain about you. We discussed it this morning with the Methodist Church. We discussed it with a whole range of other people. And if you're advising your client not to comply, I think it will help all of us here if you simply say, I've advised my client not to be sworn in, I've advised my client not to answer any questions, I've advised my client not to cooperate. And I think that Commissioner Botha will take us forward so that we can then deal with the other people who are coming.
That's why I've asked the question. I therefore ask the question once again. Is your client willing to take the oath so that we can start questioning on the matters as raised within the summons?
Commissioner Botha,
Yes.
I'm going to reiterate what I said. I said my client at no stage has he indicated that he does not want to finish any document. Can I proceed? Does not want. He never said at any stage that he does not want to finish any document. What I'm saying now, I'm saying the commission needs to make a decision on whether the summons that it was presented to us, the one that it was finished before, the one that I read, the first page, correct, as to how was it structured. This is the summons which was presented to us. Our instruction was explicit in accordance to the summons as presented to us. Now, if the commission is saying today, this is becoming an investigative study, it's something different from the summons that brought us on that particular day initially. What is said on the face. If the commission is saying they are doing an investigative study, they should have indicated we are doing an investigative study. But it doesn't say that. It said it has a complaint. I'm saying that let the commission take a decision on the summons the way it is. I'm objecting to the summons as presented to us. I've noted a number of issues in the morning.
You want to respond or should I?
Can I just confer with the chair quickly?
We'll have to take time out. I think what you need to advise your client on is whether your client is going to be sworn in, yes or no, and whatever objections you need to raise, you can raise at that point. When we're sworn in, and we're ready to proceed. If you need to object to any questions that you feel are outside the realm of an investigative study, that this place has been running for weeks now, if not months, then you can. But buying time, that is not an option. We need to get on with the job at hand. And the job at hand, the questions to be raised is not just documents, the legal advice. There are questions that are being asked everyone who comes here. Standard questions that are part of the summons. He's been told up front what he will be asked. And we intend asking those questions today, if possible. If you are going to advise your client not to cooperate, because right now, there's no cooperation. I've asked Commissioner Porter to swear him in. We're advising him not to be sworn in. So cooperation means implementation of the summons. Right now, for the past 30 minutes or an hour, we've not implemented the presence here. We've done everything but that. So there needs to come a time when you say, is he refusing? Are you advising him to refuse to be sworn in? Or is he going to be sworn in? And if you need another 5 minutes, it's okay, you'll get another 5 minutes. But we need to move on with the job at hand. This is a Section 7 committee. It's being run using the rules of a Section 7 committee and the procedure manual of a Section 7 committee, not Section 22 committees. So what you can then do, Commissioner Porter, is to have him sworn in. If you need to confer, we can ask the cameras to slow down and ask all of them to leave, and we take a decision because we don't have the time. It's either he's going to be sworn in or not, and if he's not being sworn in, then we must do what we have to do. So we'll confer on the way forward now that we have a stalemate, that you are advising your client not to be sworn in, and we can't continue with the work of the commission because you're coming up with everything. And we're saying you have a right to object when things are not what the summons said they'll be. We're not going to go down on anything else other than that. We're meeting you halfway. You can advise your client when we ask questions that no, those questions are outside the investigative study, as shown in the summons. The summons already say, these are the issues we're going to ask you, these are the documents that you must leave. And everybody gets the same thing. And everybody has been coming here cooperating very well. So it's in your hands. I think we need to move on, Commissioner Porter. We cannot do this forever. You cannot sit here forever. We need to do what we have to do because we are advising your client not to cooperate. So can we have 10 minutes, please? 10 minutes.